Hello and welcome back to RR Legal Talks. The Insolvency Bankruptcy Board of India, IBBI, has introduced a critical amendment to the Corporate Insolvency Resolution Process regulations. RPs, resolution professionals, must formally disclose fraudulent or avoidance transactions to the CoC, and not informally but officially through the Information Memorandum, that is IM. So what are these transactions? Why IBBI has the IBBI mandated this now? And what impact will it have on valuation and transparency in CIRP? So let's break it down with the full legal provisions and practical insights. Now we'll discuss the background and regulatory authority. This change has been introduced via an IBBI circular issued in July 2025 under the authority of Insolvency and Bankruptcy Code 2016, especially under Section 25, Duties of the Resolution Professional. Regulation 36 of the IBBI Insolvency Resolution Process for Corporate Persons Regulations 2016 relating to the Information Memorandum. And Section 43 to 51 dealing with the avoidance transactions. What are all avoidance transactions? Preferential transaction, undervalued transaction, extortionate transaction, fraudulent transaction. These are all avoidance transactions. 43 to 51. Section 43 to Section 51 of IBC. So the new requirement is now RPs are now required to include details of identified fraudulent and avoidance transactions in the Information Memorandum and update the CoC periodically. Earlier, this was not mandatory, discretionary. So earlier it was informal step. Now it is a statutory obligation of the RP. So what are avoidance of transactions? So avoidance of transactions are first preferential transaction under Section 43. Transactions giving preferential treatment to certain creditors over other before CIRP. And what is undervalued transaction? Section 45. Where assets are sold or transferred at significantly lower value than market price. And what is extortionate credit transaction? Section 50, where the terms of the credits are unconcernable or unfair credits. Then what is fraudulent transaction? Section 66, transactions intended to defraud creditors, avoid debts. These transactions can reduce the asset value available for the fair resolution and must be disclosed timely. And Information Memorandum, now it is enhanced scope. The Information Memorandum is the key document under Regulation 36 listing financial of the corporate data, so financial details, and a list of the assets and liabilities, guarantees, related party transactions, claims admitted. Now it will mandatorily include identified avoidance of transactions, fraudulent or wrongful trading, and status of applications filed before NCLT under Section 43 to 51 and 66. So IM must be periodically updated and provided to CoC by the RP. So now the disclosure to resolution applicants. Another critical update. The resolution plan must now clearly state how much fraudulent or avoidance transactions are proposed to be dealt with. This will help resolution applicants to ascertain potential recoverable value, adjust their bid valuations accordingly, avoid undervaluation or speculative pricing. So the benefits and the impact with these amendments: transparency for CoC. Previously, CoC members often had only informal awareness of such transactions. Now they get documented proof in the Information Memorandum. And better valuation. With the knowledge of locked-in avoidance of transactions, resolutions applicants can appropriately value the company because they know the fair transactions. and speedier decision making. Even though NCLT disposal may take some time, CoC now factors in the possibility of recovery right from the planning stage. Accountability will increase. RPs are now directly responsible to ensure this information is brought to CoC in time. This promotes process discipline. Though earlier CoC was informally aware of such transactions, now it becomes a formal part of CIRP. This enables better price discovery and the maximization of value for creditors. So resolution applicants often remain in the dark about ongoing avoidance applications. So this change improves market integrity and bid confidence. So the compliance checklist for RPs: conduct through forensic review for past transactions and thorough forensic audits, file necessary applications under section 43 to 66 before NCLT, include all relevant details information memorandum, all the details in the information memorandum, share updated IM with CoC at regular intervals, inform prospective resolution applicants of pending or decided avoidance of actions. So if you like this video, share, subscribe. We have two channels, RR Corporates and RR Legal Talks. So hit the bell icon so that you will not miss any of the latest videos. Thank you.